Our subject today is going to be the judiciary, basically the federal court system of the United States. We have a little bit different system than a lot of other countries, and a lot of it has to do with where the power resides in your country itself. And so with our country, our power actually wasn't supposed to originally reside with the Supreme Court or with the court system, although it can be argued that maybe that's what the original intention was anyway. But originally it was kind of like the Congress was in charge, the executive department was actually going to carry everything out, and then the judicial system would just make sure that, you know, everything is done the right way. And so they're just kind of seen as just like a thing in the background. And slowly over time, a case called Marbury versus Madison, where basically there was an attempt to not approve a bunch of seats that were chosen right at the very last minute of one presidential transition to the next, which literally caused the Supreme Court to sit down and decide for pretty much the first time one of the most important, precedents that kind of paved the way as the Supreme Court being the final arbitration, final law of the land. And so the way this has generally worked over time, if we have, because we come from a common law tradition of legal decisions. And so one of the little carryovers of that is called the rule of precedent, which is the idea of stare decisis, which is basically getting whatever decision happened before is literally important to whatever decision is made in the future, meaning if they made that decision and decided something off a specific criteria, unless something has changed or they've figured out some other connection to some other constitutional issue, then basically the Supreme Court has to continue or continues to decide based off of what was decided before. And so a couple of situations happened, like Plessy versus Ferguson, which is a case that was decided by the Supreme Court, which, well, today would be socially horrible to actually go with that decision, but it took Brown versus Board of Education of Topeka, Kansas in 1954 in order to finally kind of turn that thing around. So what happened was Brown became the new precedent, whereas Plessy was basically thrown out as incorrect and no longer a valid case anymore. So remember, going forward, whatever case happened last is the most significant one, especially at the highest level. So if a local or a court of appeals decides a particular way on a particular issue, but the Supreme Court decides on something else, even if the Court of Appeals came later, you can't take precedent over the Supreme Court because it's the highest law in the land. And so, and again, if the Supreme Court decided something a long time ago, that's precedent. And so, but again, it goes up the chain. So if a federal court system decides one thing and the local appeals, the U.S. Court of Appeals decide in that over that jurisdiction decides a different way, then the decision goes that way. Now we have different jurisdictions for our Court of Appeals, which means that one Court of Appeals can decide something going one way, like an issue that's commonly referred to today that has a lot of back and forth as to, or give and take, abortion. Part of the problem with that is, one particular area of the country may actually feel one way, another country feels another way, and the judges that are responding to those particular situations are not, completely absent of the fact that that's where they're from and that's where they live and work. So sometimes there's social things going on in their particular area will affect their particular decisions. And so there's all sorts of different kinds of reasons why the court systems decide on what they do. But what it's supposed to be in the very end, at least that's the Supreme Court's way of handling pretty much all decisions, has been constitutional law. So it's whatever is in the Constitution is pretty much the law of the land. And then if you want to change anything, you basically have to change the Constitution. So there's a couple of different sources for American law. One is constitutional law, which I just mentioned. There's statutory law, which is, Congress comes up with actual laws that tell you what you can and can't do. There's administrative law, because executive departments will have their own decisions that they make. And then there's case law, which I mentioned before. It was kind of like a precedent sort of thing, and there's certain rules and regulations that kind of have everything to do with what's been decided by your congressional systems, and even your as you go down the line in the chain of command on how those particular things work. So there's two different kinds of law that we focus on in this country, mostly. And there's a couple of other little side ones like family law and stuff like that. But there's civil law and there's criminal law. So civil law is basically anything that one person can sue somebody else for. You can sue government or whatever that is, but it usually doesn't involve an actual criminal penalty at the very end of it, but it may actually, there could be some attached to it depending on different rules and regulations in different jurisdictions. But what it generally means is at the very end of it, a money decision will be made, or a decision as to whether or not you can and can't do something will be decided. And then the other side is criminal law, which is basically, and these are crimes committed against the public as a whole. So you have the government that does the enforcement of this and the bringing charges and then the whole trial and everything. So government pays for that because it's in the public interest to actually do that. The difference between how you find somebody yes or no, or guilty or not guilty on whatever types of crime or types of law we're talking about, civil law actually requires a preponderance of the evidence, which means the majority actually decides one way or the other. If you have a tie, you basically have a tie and it doesn't actually go forward. You may have hung juries and just have to, and the trial basically gets redone over again or dismissed. And criminal law, which means you have to prove beyond a shadow of a doubt, or whatever the term is. Basically, it's 100%. And so there's been attempts to move it back to, more of a preponderance of the evidence kind of a thing, if the majority thinks that or whatever. But people have been struggling against that one for a long time. And it's very dangerous to take away some of that stuff. And so people tend not to really want to go that particular direction. So next thing we're going to talk about is jurisdiction, which is, it means the authority of a court to hear and decide a particular case. We often see it as like areas. So like you have a jurisdiction in this particular area as in location. But jurisdiction can also be, I have the right to hear over a case involving, a particular kind of a law, it could be criminal law, it could be the court system for families, whatever, Social Security, whatever particular jurisdiction area, meaning the area that they're allowed to actually cover, and it doesn't have to be just a location, it can actually be a type. So, and then you have the standing to sue, which means you have to be able to be somebody that has a right to sue. and that gets decided also through the court system. And then there's very specific court procedures that you kind of have to follow as you go forward. So our federal court system is made up of, from like the lowest tier of it is the U.S. courts, U.S. district courts. Then there's the U.S. Court of Appeals, and then there's the United States Supreme Court. So, like I said, the Supreme Court is the law of the land, or the final arbitrator of the land. But that being said, if the Supreme Court does not decide to hear a case, then your final court in the land that heard your case would have been that Court of Appeals for your particular jurisdiction. So let's talk about the federal court system itself, like the U.S. district courts. Like I said, it's the lowest tier of the federal court system. These cases are usually decided by a judge. There's sometimes a jury involved. You sometimes have a choice on it, and sometimes it's just by what kind of cases they are. Like during the pandemic, there's situations where it was difficult to actually get people into court, so sometimes they were done through televised appearances, and so that kind of cut back on the people that were actually hearing these things. So it became really difficult, and sometimes you have to be really cognizant of kind of like what's going on to see how to deal with like any sort of little nuance in the system. There's always at least one federal district court in every state, and there's one in the District of Columbia. There's generally about 94 judicial districts in the country. Then the U.S. Court of Appeals, there's 13 of them. There's 9 to 10 of the actual geographic locations, and then a couple of others that have very specific purposes actually in what they actually do. Some, like there's a circuit court, there's like a technology court. There's, like I said, and they're very specified in what they actually do, because it's really important that they learn what they're supposed to actually learn in doing these things. And again, one of the other district court areas, or the 12th district, is like the DC circuit. So it's basically covers all of the District of Columbia. Keeping in mind, the District of Columbia is a territory of the United States, but it's not part of a state. So you have to have some place where it can actually fall into. And then, like I said, there's the 13th one, which is basically it's the Federal Circuit, and it handles a lot of specific types of kind of cases and stuff like that. So let's talk about the United States Supreme Court. Generally over time, it's been 9 justices. They're not always, doesn't always have to be 9 justices, and the president could actually increase the number if he wanted to. As a matter of fact, during Franklin Delano Roosevelt's presidency, he almost added the number of justices because he couldn't get any of his New Deal legislation passed. So basically, he threatened the Supreme Court with adding, 5 or 6 more people to the Supreme Court, which would diminish all of their power, at least the power of each one of them. And people say they saw the writing on the wall, and then immediately started citing, or slowly started citing, towards the things that he actually wanted done. And he never actually went and did it because of it. People say because of that, but people wonder if there was really a correlation between the threat and the actions, or the carry through, or lack of carry through. And so what happens is the Supreme Court wants to hear something, and hear a case. It usually has to be, not usually, it has to be something that's been, decided beforehand, unless it's a very specific national issue that needs immediate attention, like a presidential decision or executive order that may be declared or believed to be unconstitutional. So Congress will appeal to the Supreme Court, and then the Supreme Court may hear something like that. Otherwise, what we have is called a writ of certiorari, which is somebody puts forth a written request to actually have the higher court. I'm sorry. This is the order from the higher court asking the lower court for a record of the case. But the writ of certiorari comes. I can't even say it today. Basically comes from the request to actually get a higher court to actually hear it. But again, the Supreme Court can decide to look at something on a lower court just because it's a Supreme Court. It can actually do that. But in order to hear a case, so something that may go in front of the Supreme Court, has to have what's called the rule of four. At least 4 of the justices have to actually want to hear it. Doesn't mean they necessarily all agree with each other on whether or not to decide one way or the other. It just means they all want to hear it at that particular time. And so it may be any type of issue. That's how all issues actually get pretty much put forth onto the Supreme Court. So keeping in mind, not all cases reach the Supreme Court. As I mentioned before, if you don't get the Supreme Court to want to hear your case, your last, hearing was the U.S. Court of Appeals, and that's the last you'll ever hear of it. Or like the Congress, when they ask the Supreme Court to look at something, the Supreme Court says no, then basically that's the end of the issue right then and there. So Supreme Court opinions are done in 3 different ways. One is, they have the actual opinion itself. We have what's called a concurring opinion, which is like another justice who writes an opinion in addition to the opinion, but is on the side of whatever particular decision was actually made. And then you have a dissenting opinion, which is somebody who completely disagrees with disagrees with the decision, and then writes whatever their reason is for it. Quite often, those dissenting opinions can actually become part of future case law, which is kind of important. I mean, these are not just, decisions that get thrown out because you didn't get onto the winning side of it. So we tend to not have a whole lot of Supreme Court opinions, and part of the reason for that is there's not a lot of them, and there's more and more cases that keep wanting to go in front of them. So what they'll generally do is they'll look for a case that's constitutional, that requires, in their minds, further clarification because it's important on a much bigger issue. It's usually, in most cases, not important what the specific case was at that particular time. They're dealing with precedent. They're building precedent on pretty much everything that they actually did. So let's talk about the federal judicial appointments. These are lifetime appointments. And the way it works is the president, he gets suggestions and recommendations. It's all sorts of different ways. During earlier administrations, the president would get something from the American Bar Association saying, these are the people we recommend for this position. There's been a lot of movement away from that by specific presidents to where a lot of the appointments that they're actually doing are a lot more political and a lot more issue generated. So if a president feels a certain way towards one particular issue, he may decide, I want this person to be a justice. And then what ends up happening is that person goes up in front of the Senate, and the Senate decides yes or no whether or not this person will be approved. They'll have a hearing. And so those hearings sometimes will be really, really fast, depending on whether somebody's already massively respected, or it may be contentious, and sometimes they don't get approved because it takes a majority vote of the Senate in order to confirm that particular nomination. So a couple of ways that they can be nominated. We have senatorial courtesy. And I've mentioned before the idea of like the American Bar Association putting forth names, but usually those names will go to a senator, and the senator will then go to the president and say, these are people or this is something I think you should be taking a look at. Partisanship is a huge way of actually doing it now. Like I mentioned, some presidents have very specific issues and want somebody to rely on to decide things for them or in their way. And then also the courts of appeal are quite often great places to grab different types of people that can actually serve as federal justices. Because I mean, you get a good idea of who knows what they're doing, who knows what they're talking about, and also presidents can get a good idea of kind of how they handle themselves and how they make their decisions. Almost 20% of presidential nominations for the Supreme Court have been either rejected or not acted on by the Senate. That's just kind of how it works on confirmation or rejection by the Senate. Under George W. Bush, we had a couple of people who were actually suggested and actually approved by for the Supreme Court, such as John Roberts and Samuel Alito. And then under Obama, we've had a couple of them as well, Sonia Sotomayor, and Ellen Kagan was another one, basically as a Solicitor General. And under Trump, you've had a few of them, Kavanaugh, can't even say his name correctly. And so basically when people leave their positions, or retire or pass away, someone has to replace them. And that's kind of how it works, and the president puts forth somebody else. Kind of like you would do with the regular judicial system, with the regular judicial nominees. He also nominates Supreme Court justices as well. And that's a really important, sometimes very political situation. So let's talk about the courts as policymakers. So there's this idea of broad language, and it's the idea that the text of the U.S. Constitution was set forth in broad terms. So it wasn't really meant to be, very exact in how it's actually supposed to be. And so what ends up happening is the interpretation of this, or the belief of this, is if it's somewhat vague, then when they make decisions and judges make decisions, it can sometimes be how a judge feels about a particular issue to actually decide one way or another, because he or she will look at that particular case that they're seeing at that time and go, well, this is what the Constitution meant, and then interpret it that way, as opposed to exact literal kinds of interpretations. So we have what's called the power of judicial review. And this is the power of the courts to decide on the constitutionality of legislative enactments and of actions taken by the executive branch. So if the president decides to do something, what happens is it can be challenged by the court systems. And sometimes they'll do it without anybody even asking them to look at it. And so a local district judge may strike something down from the executive department, and again, it gets appealed and then brought up to the next level, whereas like the U.S. Court of Appeals, and if they decide one way or another, it could then be appealed up to the Supreme Court as well. So that's kind of how the process works. It's just kind of like a up the ladder sort of thing until you pretty much run out of rungs of the ladder. So the other way is called or the other concept of the judicial controversies is judicial activism versus judicial restraint. Activists generally tend to be I'd say politically ideological, whereas judicial restraint is kind of like not trying not to use the court system in order to push forth personal agendas. And there's often a huge struggle back and forth between the two of them because there are Supreme Court justices and federal justices who believe one way or another, and some are activists, some are restraint people, and depending on that could help make a decision kind of going forward. And remember, the higher level sets precedent, so if I felt a particular way and I'm at the highest level, that means a whole lot of people below me who may not even think the same way I do kind of have to. And that's how the system actually works. So let's talk about the ideology of the Supreme Court. Like I said, it's not supposed to be partisan, but it happens because people are people. And so you're kind of stuck with that. Over the years, the court system has seemed to take one or the other side. Sometimes it all has to do with how many people of a particular ideological bent were put onto the court by specific presidents. So if you have a lot of Republican presidents who put people in one after another, you may have a stronger conservative Supreme Court, and then vice versa if it was more Democrats putting them in. And so that's why there's often a huge, huge fight every time somebody's getting nominated for the Supreme Court, because one side always wants to make sure whoever gets put in there is going to always, swing favorably towards them. And so for the longest time, our Anthony Kennedy, Justice Anthony Kennedy, he was basically our swing vote. So he was literally in the middle. And so you'd have conservatives and liberals kind of going back and forth, and whatever decision he came up with or decided on was usually the way it was going to go if there was a, 4-4 decision. Now it's kind of a little more skewed towards the right side, to where he was no longer considered the swing vote anymore. And so that's gotten, it's switched a little bit to the other side. And again, that has a lot to do with a lot of very recent presidents have been Republicans, and they've been the ones to actually put people in office. During the Obama administration, there's basically an attempt to put somebody in office, and it was kind of stopped by the Senate. And so Mitch McConnell decided he did not want that person put into office, and actually didn't want anybody that was liberal or any Democrat president putting anybody in. And so he halted it all the way until the next election, and it worked out in his favor. So that's how politics works. And so there's no way to just distance yourself from it, because the two kind of run hand in hand. So let's talk about different kinds of legal interpretations, strict versus broad, which we kind of mentioned a little bit before. There's strict construction, which is basically to interpret the Constitution strictly and not legislate from the bench. There are some very steadfast ones like this, like Scalia tended to be more one of these before he passed away. There was a broad construction, which is to look more into the purpose and the context of the law. So there's a number of justices that have always felt this way. Textualism, which is, you look at the exact case of the law. Now, I mentioned Scalia is a strict construction, but at the same time, he was also a very strong textualist. He looked at the exact text of the law and said yes or no. Basically, that's how it was. But the way he did it was through a more strict construction, kind of, if that makes any sense. So one of the other ones is called original intent, which is there's been a move to go, this is what I think the founding fathers thought, and then therefore interpret something that way. It's just it's a mindset of a Supreme Court justice if he or she decides to go that particular direction. Then there's originalism. There's all sorts of the idea is you kind of look at all these different things, and together 9 people are deciding for different reasons, and then the people arguing in front of them have to like appeal to the realization that somebody may think a particular way, and that's why there's so much study done on every one of these justices in order to figure it out, so nobody walks in and starts making a case realizing not a single justice is going to side on their side, or only 1 out of 9. So a couple of criticisms of our federal courts is basically a lot of people don't like policy making from the bench, and so that's often seen as a huge criticism. There are some justices who are, I don't mean just Supreme Court justices, I mean justices in general, who are very set in kind of the ways that they actually do things and have no intention of changing. And remember, these people got a job for life. And so when you get a job for life and no one has the ability to take you out without impeaching you, which means you have to actually physically do something wrong, well, not physically, you have to do something illegal or yeah, you get the idea. And so part of the other concern is there's efforts to interfere with the court's authority, which is trying to put more constraints on the Constitution, on the court system, on the courts and the justices. And so what often happens is it ends up being a backlash against the Supreme Court and the local court systems because, you know, if somebody in power, a person that got elected to office, sometimes will run on the idea that the court system is completely wrong for doing the things that it does. And so that becomes a real problem. There's also a number of cases that have happened over the years that become very political just because they create such passionate issues about specific things that people pay more attention to that than whether or not the legalities of something should be or should not be this way. And when you have very, like strict interpretation justices arguing, I'm doing this because that's what the law of the land is, or the rule of the law, people look at that and think that they're ideological rather than, being more symbolic or more steadfast in the process that they handle all their cases. So there's an approach or a desire for judicial restraint that gets put out there quite often. Unfortunately, it's very difficult to put in because you have to change the system to make that happen, and people generally aren't doing it. So one of the other checks that government tends to do, or politicians tend to do, is appropriation of funds. So we give a certain amount of money to, the court systems. If they're not doing things we want, we don't give them everything they've ever wanted, And so these kinds of things, people are humans. They're gonna do what humans do. So if you're taking away all of their benefits, like if you took away their health care or something, they're not going to do that. But if they did something like that, then it would cause people to go, oh, wait a minute, I need to be a little careful here because this is not good. And so there's always been that attempt to make sure that sort of thing doesn't actually happen. So over time in this country, people have a strong sense of the Supreme Court is actually a good thing, or the court system is a good thing, because it's always been seen as impartial and not really subjected to the ideas of politics. Unfortunately, that's not always the case, but the perception is always there, which makes it really difficult for the executive department and the legislative department to actually institute any changes or oversight over them, because they're seen as good, whereas they're not often seen in such favorable lights. And so, but going forward, keep in mind the Supreme Court and all this is, I mean, it's part of the foundation of our country. It's one of the three branches, and there's a reason why it serves as one of the strongest branches. Other countries, I mentioned before, they have different situations. There are other countries that actually don't have as much power vested in their Supreme Courts or their court system. And instead, they're more interested in their legislation being in charge, and then the Supreme Court just kind of acting as you did it right, you did it wrong, you didn't do it wrong. But even they're not allowed to overturn things that the regular government is actually doing. Whereas our Supreme Court and our court system is completely different. Whereas they are, as I mentioned, the final arbitrator of the land. And that's important. And so keep that in mind, because remember, when that precedent is made, that previous decision, that's the decision that's going to push things the way things will go for the future.